limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it is kind, and has been stated as the fact that we do not have an IEBC. My lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IBC if really there's a political crisis. Finally, my lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. because one
attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done, as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is a question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the whole... Dr. Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.
I wish to make an application under Article 57 of the Constitution. All the members of the society. The owner is now 2:30. Some of us have to eat at certain intervals. And I'm mindful of the court. You have been sitting all the time. You must be now very tired. Let us adjourn and we'll resume in the afternoon.
My lord, I would like to support the request, very polite request from Dr. Haminwa. Dr. Haminwa is the #1 longest serving member at the bar. And yours truly is #2. So my lord, breaking for an hour or so is a very appropriate thing to do, and I ask the court.
We want to break by some order.
Yes.
We want to complete the applicant's case. Then we can break.
Okay. We will persevere.
You are the last one.
Yes, my lord.
How much time do you want?
I need 5 minutes, but I would appreciate it if you don't knock because I have dyslexia, so it will make me start rapping instead of delivering my submission.
I finish, please.
Yes, my lord.
Your name?
My name is Wanjiro Mwangi. I am the 12th petitioner in consolidated file E65 of 2024.
And together with the 11th co-petitioner, Dr. Eboso, we asked to be enjoined as interested parties in this matter.
My lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I ask for time, not to rush me, so I can articulate myself properly. My lords and my lady, I would like to ask this court to deem myself and Dr. Eboso being properly on record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly on record.
That I want to task to the judiciary and to the members and to the public and to everybody else. Question number 1, the judiciary on trial. My lords and my lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class, locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2).
Justice shall be done to all, irrespective of status. read together with Article 27.2, which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms.
Protection and equal benefits of the law. Question number 3, the laws on trial. My lords and my lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives and guarantee all the petitioners, especially those who prayed for conservative or injunctive orders whose applications have not been heard and determined, including us laymen, the right to a fair trial as specified in Article 50, which reads, every person has a right to have any dispute that can be resolved by the application of a law decided in a fair and public hearing before a court. Read together with Article 27.3, women and men have the right to equal treatment, including the rights to equal opportunities in political, economic, and cultural spheres. Question number 4. Immunity of the office of the president is on trial. The inadvertent question we as a society have to ask ourselves is a moral one. Does the court have any real authority to successfully reverse the impeachment and reinstate Rigathi Gachagua? Based on the truth we know, the truths we have been shown, and the truths we are constantly reminded of by the political pandemic we have been suffering, what confidence does the public have that if the conservation orders are lifted, the court will have any real authority to successfully reverse those orders? Then, under the same assumption, the ascension of Professor Kindiki will succeed after that in a manner of what we expect to be ours, despite the numerous legal ambiguous queries about gazette notices in the middle of the night and a lack of IBC commissioners to vet or validate the public participation in that matter.